Mr. Naidu, you are still under oath.
Thank you, Noted Chair.
Mr. Madonsa.
Thank you, Chair. Mr. Naidu, before I ask you some questions regarding your evidence today, can I please ask you to take a look at the document that I will circulate amongst the members of this panel and our learned friends now. The first page is an affidavit by Mr. Mzwabantu Mhlonhlo, who's
Mr. Madonsela,
Yes.
can you also provide me with a copy? I don't have a copy.
Oh, sorry, my apologies.
Oh, thank you.
I'm selfishly keeping two.
Sorry, Chair, can I just ask, do we have a reference in the papers?
That's the point.
Okay.
That's exactly my point. I want to ask from this witness to you, Chair, if the evidence leader gave you a copy of this affidavit by Mr. Mhlonhlo, who's the court manager of Mthatha. In the next page, there's an email addressed by Mr. Mhlonhlo to the evidence leader attaching this affidavit. Now, the point, were you given an opportunity to look at this affidavit before you testified?
Negative.
Sorry?
Negative.
As I indicated to you, this is an affidavit of the court manager. You know Mr. Mhlonhlo, don't you?
Yes, we've spoken on the phone a few times.
He is the one responsible for the court management in Mthatha High Court, not so?
That's correct.
His evidence that was given to the evidence leader in this case, as appears from his affidavit of 18 February 2025, some 3 months ago, says he gave the permission, or he asked Wanga, Mr. Wanga, who is a security guard and who's working in the control room, to assist Judge Dorota to view the footage. Not so?
That's what the affidavit says, yes.
So the viewing of the footage by Judge Dorota on that date, whatever the date was, came with the sanction and the blessing of the court manager, not so?
According to the affidavit, yes.
Just a second.
So this information is an important information to narrate, to give a proper narration of what happened when Judge Dorota viewed the footage, does it not?
It does?
But it seems to me that it was withheld from you as it was withheld from us and the panel. copy?
Shouldn't we start by saying it wasn't shown to you?
It was shown. It was not
If it
shown.
was withholding, it's your choice. If you persist with withholding,
was-
that's your choice. But I'm just saying withholding may have certain implications.
Yes. Chair,
Yeah,
I
you
take,
know what I mean.
I take guidance.
Yes.
You're right. It was not
wasn't-
shown.
Yeah,
It was not shown to us. It was not shown to you. It was not shown to the members of the panel. Yet it would have been important for your evidence to give a proper picture of the circumstances in which Judge Dorota viewed the footage, not so?
It is, Advocate. If I may add, in my testimony earlier on, I've indicated that there is a procedure that we apply when footage is requested from any of the control rooms at the superior courts. And that is not, as much as you've indicated in the affidavit, it's with his blessings. He's not the one to give the blessings, if I may put it that way. So in the procedure, any request, whether there is a appointed investigator from within the department or another government department or from SAPS, they will provide that appointment letter to say that I'm the investigator in this matter. I'm requesting footage from this date to that date, this time to that time. That will go to the provincial security manager, which was in this case was Mr. Mabuza, and that would come to my office for approval. So that way you are basically having the proper access to the footage. In this case, it was not. Although this is this was not shown to me, but it's still not the correct method. Not as I testified earlier on.
Yes. You see, I'm not acting for Judge Dorota, but from the perspective of Judge Dorota, the first port of call is the court manager.
That's
Not
correct.
so.
That's correct.
And it is for the court manager then to direct him to the right channels, not so?
That's correct.
And he went to the first port of call, which is Mr. Mklonto, not so?
That's correct.
Now, Mr. Wanga is mentioned in this case, and you mentioned him in your evidence. He was a control room security officer, not so?
That's correct.
I have to ask you these questions because, surprisingly, we were told by the evidence leader that they don't intend calling Mr. Wanga. So I have to ask you some questions arising from Mr. Wanga's affidavit. Please go to page volume 5, page 867.
I have it.
just a minute. Page what?
867.
Sorry?
867. Firstly, before I put questions on this document, have you seen this document before?
Yes.
It's the affidavit of Mr. Wanga, which is dated the 11th of March 2025. Mr. Wanga gives testimony on oath, and he says, I'm Wanga, I'm the one who managed to retrieve a footage of the incident requested by Mr. Naidu. Let me stop there.
Yes.
Is it correct?
That is
You
correct.
requested him to retrieve a footage of the incident.
Not entirely. The footage that we requested when I spoke to Mr. Wanga is the footage that was on the hard drive of that computer, the one that was saved by Mr. Mabuza, or saved by Mr. Wanga on Mr. Mabuza's request.
Well, let me go on. I'll come back to your comment about it.
Okay.
And then he says, describing you, who is the DOG official. I retrieved the footage and saved it to USB
Yes.
as requested by the above mentioned DOJ official. It is my part to do so as I work for Mr. Rubis as a control room operator. That's the end of the affidavit. So the essence of what he's saying says, at your instruction, he retrieved the footage and saved it on USB.
Okay. So Advocate, let me put it into perspective in terms of how he's referring to the events. So at the time of me requesting the footage, I was given his contact details by Mr. Mabuza, who had then left the OCJ. Mr. Mabuza indicated that they did have the footage on the hard drive of that PC, and that I should engage Mr. Wanga directly to retrieve that footage. At the same time, I've contacted both the court manager and Mr. Wanga to make sure that they place that footage, the footage that was already copied to the hard drive. So it was not on the system. It was the footage that was copied onto the hard drive that I requested to be placed on the USB.
So let's get the facts correctly. It is Mr. Wanga who says he copied the footage and he retrieved it and then saved it on a USB.
Not in that motion. Let me put it like this. I think on the day that Mr. Mabuza reported to me that the footage was viewed without the proper procedure, that was the day I asked Mr. Mabuza, please secure the footage. His discussion with Mr. Wanga managed to secure that footage on the hard drive. My request from Mr. Wanga and Mr. Mshoncho was actually to have that, as he stated, to place it on the USB, that which was already copied from the system onto the hard drive. That was the request that was made to him.
Did you have discussions with Mr. Wanga?
It was brief. It was brief, just to explain that I've already contacted the court manager. Court manager will come with a USB so that you can copy that data and provide it to us.
Let's move. There is another affidavit that was deposed to by Mr. Wanga.
Yes.
It is at page 868.
All right.
Now, I'll take you to. Are you familiar with this footage, with this affidavit?
Not in so much detail, no.
It's a later affidavit. It's dated 13 March 2025. At the bottom, can you see that?
Yes, I see that.
Now, this affidavit gives a different picture. It's written in a handwriting that might not be easy to read, but the feature of this affidavit, it seems to me, was a response to some questions, because in some portions which I will take you through, it starts with a yes. I'm taking you to line 1, 2, 3, 4, 5, 6, 7, 8, 9. The ninth line starts with a yes.
Seventh line.
Sorry?
It's the seventh line that
9.
starts with a yes.
Now there's a yes, then 7, go down, 2 lines down.
Okay, I see that.
let's start with the first one that you say, the one on the 7th line. He says, yes, it was saved in USB by order of Mr. Naidu, as well as court manager. Can you see that?
That's right.
Sorry.
Line 7.
Are we on 868?
868, yes. Yeah.
Okay. Okay. Where you end on 60 depends where you start counting.
I start under the
But-
word state under oath in the English. That's I start
Okay.
there from 1.
Oh,
Line 1 to line 7.
you count the big letters.
Yes.
Anyway, yes, you just read that portion.
Yes.
again.
And I'm saying that it seems to me that he may have been answering questions, and then he starts the sentence with a yes. Can you see the first yes? Yes,
see
it
that.
was saved in USB, as if answering a question. By order of Mr. Naidu, and as well as court manager, was give permission to judge to view the footage with the system. So the impression that I get from this statement is that he is answering that question, says, yes, I saved the USB as ordered by you in concurrence with the court manager. Is that correct?
That's what it reads, yes.
No. Is that correct?
To save the footage onto the USB,
Yes, it was saved by him
that's right.
as ordered by you,
That's right.
as well as the court manager.
That's correct.
That's
So
correct.
I did speak to the court manager and I spoke to him as well when we downloaded the information onto the USB.
And then he says, the court manager, and then I think he means who gave permission the judge to view the footage with the system.
I'm not aware of that. So I see that is the statement that was given by Mr. Mhlonhlo, and it's also confirmed here, unfortunately without the punctuations in the correct places, but no, I did not give permission to the judge to view footage.
Yes. Now, let's move on. In the next yes, he says, yes, the footage of the 14 to 16, can you see that? Is on the system.
Yes, I see that.
Now, it seems to me from what he's saying there, this is the 3 days that were covered by the footage, 14, 15, and 16. He used the hyphen, 14-16, 14 to 16.
Yes,
Surely it must be covering 3 days.
I can't confirm for him what he meant in the statement. Could have meant 14 to 16, could have meant 14 and the 16, so I can't confirm.
No,
for him.
it can't mean anything. It's 14-16, hyphen 216.
It's possible.
Yeah.
It's possible that's what he meant, but I can't confirm that.
No, please. 14 to 16.
In my understanding, Chairperson, yes, you are correct. It could mean that.
It means that, Mr.
But I'm not sure if he meant the very same. So it could mean that.
Are you suggesting he could have meant something which he's not saying here?
It's possible. Because even if you look at how the context and the language is not very coherent in terms of how he's explaining his sentences and where it stops and starts. So, but we'll accept that he could have said 14, 15, and 16. We'll accept that.
So you say that is not what you received. You didn't have the 16th,
No, I didn't have the 15th.
the 15th.
15th. We have the 14th, we have the 16th on the recordings.
And we know from Judge Togota's evidence that he viewed the 14th and 15th.
That's what he said, yes.
And this seems to be to tally with what Wanga says was saved at the time.
It's possible.
Now, you say you spoke very briefly with Mr. Wanga.
That's right.
Now, I have to ask you this because Wanga is ultimately responsible to you through some other person, Mabuza.
Mabuza, yes.
So can I get the question correct? Because I don't want to build on the question when you have answered it wrongly.
All right.
The question is, Mr. Wanga is ultimately responsible to you through Mr. Mabuza.
Not necessarily. Mr. Wanga is a contracted official. He was a contracted official. So in other words, he's basically has his own, he's got his line of functioning with his private company or the company that he works for, but under Mr. Mabuza's supervision.
Mabuza is working for who?
Mr. Mabuza works for the Office of the Chief Justice, or worked back then.
Now, the information that Wanga relayed, which ultimately filtered to you,
That's correct.
came through Mr. Mabuza,
Came through Mr. Mtlontlyo,
Mr. Mtontla, not Mr. Mabuza.
not Mr. Mabuza.
Now, so you would occasionally speak to Mr. Mabuza under what circumstances?
We would speak often around different security matters, different courts, different judges under protection, high-risk cases, and so on.
So you would speak to Mr. Wanga now and again?
No,
You speak to who? To Mr.
I
Mabuza?
speak to Mr. Mabuza.
Oh, and then Mr. Mabuza speaks, if it's a specific matter, he'll go to Mr. Wanga and ask what happened on a specific issue.
He would, but remember, Mr. Wanga had also a line function in the company that he worked for. So they also have site supervisors, area supervisors, area managers, who Mr. Mabuza would first engage if there's any issues. But regarding the security footage at that court, then Mr. Wanga is the one that Mr. Mabuza may speak to.
The reason I have to ask you this, and I have to be specific about this,
Right.
is to ascertain whether you get reported on in relation to anything that happens that has security concerns in the building by Mr. Wanga.
Not by Mr. Wanga.
So you are not in a position to comment about a security concern that was raised by Mr. Wanga with the court manager or any person in the building, in the court building.
No. So like I said, there's line functions in the court building. So if I could explain in this way, the Eastern Cape Division has 4 superior courts spaced out throughout the province. Mr. Mabuza is located in East London, okay? And he's reliant on the service providers that provide security functions at the different courts. So at some places, we might have our own in-house security officers that work for the OCJ, and they work inside those control rooms. So that people will have a direct line function to us. But in the case of Mr. Wanga, he worked for an outsourced service provider. In other words, he had a line function within his company, and then he also had the line function, which is the court manager, and then also through Mr. Mabuza.
Let me ask you, maybe be specific about this. If there was to be any changes in the biometrics in the court building,
Right.
would you be informed of that?
Any changes in what sense?
In the biometrics?
Okay, in what sense? If there's for example, if a new official arrives at the court and they capture that, which we call enrollment, if they capture that, that will not be conveyed to me.
Or if they change all biometrics and take new ones?
Right. So in other words, if they scrub the entire system, and no, that would not be communicated to me.
So you are not in a position to give enlightenment about whether Wanga was told by anyone that biometrics are being changed?
No,
So it will be Wanga who will be able to give that information.
might be him, yes.
Mr. Mabuza will be informed of that?
He should be informed of that, yes.
I ask because it was the complainant's case that Mr. Wanga told him that the JP had instructed him to change the biometrics in the building. You wouldn't know of that.
No.
And for the
I
record,
should have known, Advocate. Sorry to interject. I should have known if something like that had to arise.
you should have
But
known,
I was not, no.
but you didn't.
No.
Well, in fact, I think your evidence in that regard accords with the respondent's evidence that he gave no such instruction.
I'm not aware of it.
Now, going to the real issue now, the footage which we have viewed today, and I'm focusing for purposes of this case to the afternoon footage. Let me just get this correct. You are saying that the footage, the second footage that we viewed, starts at 15:11.
Yes, I think so. Just make sure. At 15:11 and 47 seconds.
Okay, please just leave the seconds out of the question for now. 15:11.
Right.
It is 11 minutes past 3 in the afternoon. Not so?
That's correct.
And what was seen right at the beginning? Do you have the minutes that we?
No,
we
I don't.
shared?
I don't have that. Is that starting from point 29?
Yes. Now, you say that as it starts, it shows Miss Mango walking down the passage and exiting through the door near the camera, which is chamber 1 door. Correct.
That's right.
And the next thing we see from the footage is Miss Mango in paragraph 30 entering again through the chamber 1 door. And I just want to remember this, to recall what we saw. When she re-enters the building through that corridor 1 door, she does not get anywhere near the judge president's chamber, not so?
Not from the footage, yes, you're correct.
Sorry?
Not from the footage that we saw.
And under item 31, when we see her later, she is seen coming out of the chamber 1 door through that same door without having reached the JP's office. Not so?
That's correct.
And I just want to find out from you if you recall, before I suggest this to you. She doesn't come back again ever in the building from that point.
So,
From the footage, talking about the footage.
from the footage, yes. So obviously there's a reasonable assumption for that, is that there's more than one entrance to those chambers. And it is very possible that a person can exit the door that we were watching on the video, right, and go around the other way of the court and come into the other entrance. So basically, to make sure that there's also an emergency exit, there's more than one access point to enter chambers.
Yes, but I'm limiting myself to the footage. Because
Right.
the footage, let's not hypothesize about what can happen.
Right.
You know, many things can happen in this world. Let's talk about what is in the footage.
Right.
In the footage does not show Miss Mango coming into the building after exiting through exit door C1, not so?
That footage doesn't show that.
And what we see from the minutes is that Zinhle, at paragraph 35, is in fact seen walking down from passage in the direction of chamber 9. You know chamber 9?
Yes, I see it.
And exit through door 1. Can you see that?
Yes.
And we also see Zinhle re-entering the building through the same door, corridor door 1, in the company of some individuals, not so?
That's correct.
And we saw that there were combined episodes there. There was also a point where she emerged carrying a chair. And Zinhle exits in paragraph 38 and walks out of the building as the last person who exits the building. Not so?
That's what it says, yes.
So, on the basis of the footage that we saw today, it is not possible to sustain a version that Ms. Mango went to a chamber that is chamber next door to chamber number 1 and left to go to JP's chamber. Is that correct?
It's possible from the footage, yes.
Sorry?
From the footage, it is possible that.
No, I'm not saying it's possible.
Oh, it's impossible.
And there is no point where we see Ms. Mango being called, or rather moving as though he was moving from the direction of chambers, of JP's chambers, passing through JP's chambers, going to a chamber next door to chamber 1, and going back to JP's chamber. Not so?
That's correct, yes.
Nowhere in that afternoon of the 14th of November. Not so?
It doesn't show that on the footage.
Chair, I have no further question.
I thought you said, Chair, I'm not finished yet. Advocate Skippers.
Thank you, Chair. Mr. Naidu, on the footage that you have in your possession, do we have the footage of the entire day of the 14th?
Negative.
Do we have footage of the entire afternoon of the 14th?
No, we don't.
And then I just want to follow up on an answer that you gave to Advocate Maronsela is, you say that there's another way that you can also enter to the office of the JP, is that correct?
That's correct. It stands to reason, Advocate, that we would not put the judiciary in a dead-end area in the event of an emergency. So there is definitely other entrances to that area.
But we don't have the...
We don't.
Thank you, Chair. I have no further questions.
Advocate Butland.
No questions, Chair. Thank you.
just sum up the procedure for the acquisition or for the application of permission to view. You gave it, but it's not quite clear. I'm sure it can be clearer.
Okay. May I proceed, Chair? May I proceed?
Yes, please.
All right. So there would be two instances. The first instance, let me say that would be an internal, in-house investigator, somebody appointed by the OCJ to conduct an investigation within the OCJ's premises. That person would be issued with a letter which mandates he or her to acquire any evidence that they might pick up during the course of that investigation. That might include video footage. With that letter, they will have access, and we will still authorize that access to that footage. On the second instance, which is the most common one that we have, is when something happens in the court. A person's cell phone is stolen, somebody's assaulted in the court, an incident of maybe stabbing or shooting might happen in a court, and SAPS will be the investigators. SAPS will come with the SAPS, with the case number, and the investigating, the detective will indicate that I'm the appointed investigator, and I require to see the footage on this. And we'll follow the same procedure, that we'll make the submission to the national office, he'll get approval, and he will view the footage. That's as simple as it can get, Chair.
Okay, thank you. Any questions following?
None, Chair.
Thank you. Mr. Naidu, thank you for your time. You are excused.
Thank you, Chair.
Thank you. Advocate Skippers.
Chair, that was the only witness I had available for today. I cannot close my case at this stage due to the fact that I am of the view that a gender expert is necessary to testify. I agree that her summary was only provided to all the parties last week. The fact of the matter is, it was a timeless procedure to identify someone that is able to testify on the specifics in this matter. I know Ms. Vetten is readily available, but I tried to find someone from the isiXhosa culture as well as from that area that is also a gender expert to assist us, due to the fact that we had all these problems with the context and the isiXhosa translations and everything. That proved to be, I could not find anyone in that. So the fact of the matter is, when Ms. Vetten was contacted, she indicated that she will assist. However, she would need remuneration. I immediately applied to the Secretariat, or requested them what the procedure would be if a witness, especially an expert witness, would need finances for preparing and also to testify. They provided me with a procedure, and then that cumbersome process took underway. Her approval for funds only came last week, Tuesday. The approval came through. She refused to start with her report before she knew that she will be paid for it. That is the reason why the report was not available. I have spoken to her this morning again. She promised that she will amend the summary as there's an objection to the summary not being suitable, or if there's not enough information in the summary, she will provide me with another summary, an amended summary tomorrow. I could not provide anything earlier due to the fact that the approval for her funds came through last week. It is my view also, it is in the interest of justice that she should be allowed to testify, as this is a complex matter, and I understand it was complex from the start. But as I indicated, I wanted someone from that culture to assist us. I could not identify anyone. And that is the reason why it is late. I understand it is late, but that is what is the process now.
Thank you. You said you cannot close your case. I don't know if you have a case to close as the leader of evidence. I don't know. What I do want to ask, though, is Advocate Butlander whether she has a witness that she wants to be called for the benefit of the complainant's case at this stage.
Chair, you raise an important issue, which I think because of the nature of the rules in these proceedings is fairly unclear. The rules or regulations don't actually provide for the complainant to call witnesses. It's for the evidence leader to place evidence before the panel. So that is why we haven't been able to call witnesses, and we hadn't anticipated that we would be entitled to do so. So I actually haven't even given that thought. As I say, the way in which these proceedings seems to be structured when one looks at the regs is that it is for the evidence leader to lead this process. This is partly why, in many ways, the process of having the complainant even represented here is novel. It's not always the case, as in other tribunals, that the complainant is represented. So, as I say, I haven't given thought to whether or not we would want to call witnesses. I can certainly do that.
Yes, I think the rules would say that the respondent may call witnesses. So to the complainant.
I stand to be corrected, but when I looked at it at the very beginning of these proceedings, it's not, the respondent is entitled to call witnesses through the panel, but it does not say that the complainant is entitled to call witnesses. It says the evidence leader is required to place all evidence before the panel. But I'm happy to look at those provisions again. That was my recollection, which is why we haven't really been running our own case in the same way as we would do if this was a trial.
Yes, but I thought that, I don't know if the respondent could adopt, the respondent's representatives could adopt the same attitude and say, well, and say to advocate Skippers, you are the leader of evidence. It's for you to call witnesses for the respondent.
No, because the regulations specifically say the respondent is entitled to present his case.
Yes, but I would have thought that part of your representing the complainant would be to interact with the leader of evidence and say, Advocate Skippers, having consulted with our client, we believe that you should call so-and-so and so-and-so and so-and-so. And then if you did so, then I thought she would not easily decline from calling a witness that you believe might assist the complainant's case. But maybe it's not too late. I don't know. Maybe I asked you whether you feel that there's a witness that you feel should be called for the complainant's case. And I had, frankly, maybe wrongly thought that Dr. Docret was at the instance of the complainant. I noticed that you say no. That means she was at the instance of the leader of evidence. But I'm not sure whether the door is shut against you, as the legal representative of the complainant to say to advocacy keepers, we believe that such and such a witness should be called to assist the complainant's case. I don't think the door is shut against you.
It does change the, the entire nature of the proceedings, though, Chair. I'm sorry. What comes to mind is, for example, you would have seen in the way that these proceedings have been run, that the evidence leader has led the witness of each of the witnesses. And really, while I went after her, there were definitely times when actually my role was not leading evidence, but testing evidence. So this is it is an unusual thing, I accept that. And we have run some sort of a hybrid process, I suppose, trying to ensure fair process. I can certainly, I'd have to consult and take instructions, but we would ask for a ruling. Perhaps one needs to look again at the regulations and give some thought to it.
Maybe all of us should.
Sure.
Shall we shelve that for tomorrow morning? Unless Mr. Madonsela has some view.
Can I share that to Mr. Skakade?
Yes.
Chair, I don't know whether I should sort of respond to the presentation that the evidence leader made, and then, Chair, I fully understand when she says that it's in the interest of justice to call this witness. We have registered our objection, and our objection, Chair, is based on the fact that there was a directive about the rules and being fair to the other side, particularly if you're going to call a witness who's an expert witness, who's coming here to give opinions, her opinions, which always is based on the fact that the panel on its own does not have the skill to make the inferences. But that is why the rules of evidence, and correctly the directive that was issued by yourself on the 7th of April, indicates that that must be done timelessly, that a report must be given, because as much as it has, as she claims, taken it this long to get to someone who's an expert on gender or sexual harassment, we would need to take that report, which we don't have. We have a one-pager. And in that report, we would have to test with someone who's an expert two issues. One is that she deals with something that is complex, which is power relations in society. We would have to take it to someone who's like that, who's going to test her evidence, its relevance, that's for the tribunal. But we would have to test, it's a very complex matter to come and tell a tribunal when there is, or all of us, we're not experts in Antonio Gramsci or Michael Farquhar about power relations in society. So we would have to have time to read it, take it to someone who knows this concept, because we're just ordinary lawyers, we wouldn't. So we have made the objection in that the rules have not been complied with. Lastly, on this issue, I can go to the law about relevance. But lastly, on this issue, one of the things we are told why we would need an expert is that this is the first time in South Africa. This is from the...
We have a bundle.
Yes, I'm just reading this letter, which was a response, but I think it's correspondence that is there. This is the first time in South African history that a tribunal of this sort has been called upon to make a determination on a complaint of sexual harassment against a sitting judge. So this is a matter for evidence. There is no reason why a new definition of the law and of the charge on what completes the charge of sexual harassment, because the litigant is a different person. And so without getting into the legalities that have been tried principles since the case of 1957, there is an issue of relevance apart from procedure. That this evidence would have to be put here because the tribunal is unable to make inferences on the basis of common cause evidence. We submit that's not the case here. We submit it's not even justice to say the definition upon which you are called to determine on the basis of evidence would have to change if the respondent is a sitting judge. In all sexual harassment cases, by the way, they are there because there has been unequal power relations at workplace. So there is no need for this evidence, but also we've not been served with sufficient time. And lastly, Chair, and if we must go to the law about it, the cases, we can, is that on our side, Chair, I'm ready to call the judge president tomorrow morning to give his side of the story. And we submit that just on the basis of procedure and not complying with the rules, it would be unjust at this late stage if all is, the delay has been so long that this idea, even if it were correct, that this is the first time in the history of this country, if that's relevant, even if that were correct, well, this case was about the judge president since it started. So we don't know, we've not just discovered that it relates to the JP. We knew right at the beginning. As to the split between the evidence leader and the representative of the complainant, I have nothing to add. But I would suggest on both procedure and relevance, and if the cases must be cited about relevance and whether this tribunal will be incapable on basis of the evidence, would they lack the skill to draw the necessary inferences? Because you cannot call an expert if the expert's coming here is, as in that case they call supererogatory, means beyond what would be necessary. You don't lack the skills. And we can't have a witness who's coming here to tell us about her views on Fakwa, on power and the universe. It must be because this tribunal is incapable without her skill to make the necessary inferences. On those bases, particularly on the procedure and the delay, it is our submission that this witness comes too late for this process and it's unfair. This process must be fair to both complainant and respondent. And on that basis, it would be unjust to call a witness who's an expert and delay. Even the delay is unjust. We have to deal and redeem the time that we have. And in conclusion, Chair, the Judge President Mbenenge is ready to present his evidence tomorrow morning, or as soon as we finish this, we get your ruling. Thank you, Chair.
Chair, before you respond, I didn't address you on Ms. Vetten's evidence. I would like to do so in response to Mr. Skakane, but I wasn't sure if you were about to make a ruling or give us an opportunity to do that.
I wanted to split the two. The issue of insufficient time, which I thought would be an easier one. And then it would appear as though Mr. Skakane is now raising a substantive objection against the leading of her evidence anyway, which is a different thing, on which we haven't had you. I have certain views, but can I just consult with those who know better than me on my left and right hand side?
Chair, can I just make a point? And you will recall that I was responding to a substantive issue that it's in the interest of justice. If I must address you on the law, on the case law on this issue, I haven't. I left it because it would be a waste of time if I do that. But if I'm permitted, I'm saying this because my learned friend says on the substance she wants to respond. But I didn't, and I can take this tribunal to the case law and the principles that are tried and they've been set down. I didn't go that far. I was just responding to the substantive issue. Thank you.
Yes, as I say, if we have got to deal with both, you have to guide us. If we are going to deal only with the issue of whether or not sufficient time should be given for you to deal with the summary of Dr. Vettel's evidence, if you are going to deal with that, for example, you referred to the directive that I issued advising the parties on how to go forward. If you are going to deal with that, it's not a very difficult issue because it is obvious that sufficient time would not have been given to the respondent. It is obvious that that expert cannot come and testify tomorrow or even this week because sufficient time has got to be given to you. That one admits of no debate. However, that's the one thing. However, if you want to go further and mount an objection against the leading of evidence anyway on the grounds that you refer to, that would have to be a bit more substantive, and that's when you'll have to refer us to the law and so forth. But the choice is entirely yours. Do we deal with the first one, which is easy to dispose of, or are we going further to deal with your substantive application to say evidence should not be led? If we were to proceed with that one, she says you would need to have an answer. But at the same time, you say that you have not fired all the bullets. You say you could produce legal precedent or cases to support your case. Now you have got to guide us whether which one you choose.
Thank you, Chair. Chair, as I said, I mean, I didn't take you to any. I was just responding because when it was stated to you that it's in the interest of justice, the evidence leader was entering the realm of the nature of the evidence and why it's important. So my suggestion is that at this point, our objection is on the preliminary point, and the ruling that we would need is the fact that we object to its lateness because it's not in compliance with the rules, and there has been sufficient time for this matter for the evidence leader to determine that the matter is the first one in the country, if it is, and to make this decision slightly earlier than now so that no one could be prejudiced. That's all. So I would suggest, Chair, it's the first issue. And if I fired any bullet on the merit, it was in response to that. But it was a warning shot. I haven't really, I wouldn't like us to get there.
Oh, sorry, I think I missed one aspect of your argument. Your argument is saying that, no, even if they were to say that they will give us more time to look at the expert's evidence, we object. We object because we say that they should have done that a long time ago. Is that the argument?
Well, it's two. It's one, we would object in that fashion. But secondly, suppose the tribunal would disinclined to agree with us on the time delay and the preliminary point. What I'm saying is that we would expand, even if she's here, to the panel, then that we would object to the need for expert evidence in these circumstances. But I'm not there yet. I was just responding to what I thought was the realm of the need for that evidence. That's all. Yeah.
All right.
Thank you, Chair.
I think we understand that. I think both counsel would respond to that. I don't know who wants to go first, but Advocate Skippers, you and Advocate Butler.
Ms. Skippers is pointing at me. So, Chair,
let us be clear what is an issue.
Yes.
The issue here is they say that they object against the introduction of Dr. Vettel anyway as an expert, because it's late in the day. The leader of evidence had ample time she had ample time to have considered this kind of evidence and arranged for this kind of evidence. It's now late in the day. They cannot now at this stage ask to lead this kind of evidence from this kind of an expert. Do I sum up correctly, Mr. Skakani? Yes, that is the issue.
Sure. Chair, that is in fact the objection that was made in the letters sent, the correspondence sent by the respondents' attorneys on the 2nd of May. That objection was, the objection was only ever about the delay. So let me address that. If one looks at what the objection is, it is an objection at its heart about prejudice. That the respondent has been prejudiced by the fact that the summary provided to us from this witness has come very late. Now, let me place on record that it's not just the respondent that's prejudiced, it's also the complainant that's prejudiced. We received that summary at the same time. We also have questions for that witness that we would need to prepare for. So the prejudice here is a prejudice of non-compliance with time periods. Now, there are no set time periods, we know, set down in the regulations that govern this process. But even if one imagines that a reasonable time period would be the appropriate time, we accept that it's not a reasonable time period to have provided the summary on Wednesday last week. The question then arises is, how do you cure that prejudice? And our submission is, if this panel is of the view that this evidence is relevant, and so we do have to talk about relevance, then it must look at how it cures that prejudice. And how it cures that prejudice is to give the respondent and the complainant sufficient time to prepare for that witness, and specifically for the respondent to consider whether or not they wish to bring their own evidence, expert evidence. That they require time to do. This panel has already set aside time at the end of June to keep going on this matter if we didn't finish this week. And let me be clear, I, like all of my colleagues here, am very keen for this to finish this week. But if we're trying to cure the prejudice, then our submission is that can be cured by providing us with time to do that. The directive provided from the panel required expert summaries to be provided and that they be succinct. Now, an expert summary was provided. It is succinct, which is part of the objection to it. More is required of that summary. I would submit that this panel needs to hear this evidence and that any prejudice here can be condoned by this panel and cured by this panel by allowing us to hear that evidence after we've had time to consider it, and we've got time set aside for that. In terms of relevance, and I'm not responding to the substance of the complaint, but I think that the panel may, if the panel is to adjourn and consider these submissions, it may occur to the panel that in order to decide whether or not this is evidence you want to hear at all, you do need to consider whether it's the type of evidence that's correctly to be brought before you. In that respect, and I'm not citing case law, and if Chair, you require that, we will certainly prepare that kind of a submission, but I'm not in a position to do that now. But I point to one thing only, which is that in the cross-examination of Ms. Mbenenge, my learned friends asked her extensively about the definition of sexual harassment, about its manifestation in the workplace in relation to power imbalances between the respondent and herself. She was specifically asked, and I objected at the time, but she was specifically asked about the social theory of power relations. She was asked about her understanding of overt power and soft power and the theoretical aspects of power. Now, I'm not sure that I can answer those questions myself, and I would imagine that none of my colleagues can either. But that is why we require an expert to come and tell us what those things are. So understanding in this case the conduct of the parties, the nature of the engagement, requires not just an evaluation of the facts, but also of the context in which all this happened. And it seems to me that that is why this expert evidence is required to be heard by the panel. So we would submit that the evidence must be heard, that the prejudice must be cured by allowing us, both the respondents and the complainants, time to consider the summary that we're told will come tomorrow, I think I heard, and to prepare. And if the respondent wants to bring their own expert, of course, they're entitled to do so. Those are my submissions, Chair.
Yes. I'm not sure whether you are on the same wavelength with Mr. Sikakane when it comes to the cause or nature of the prejudice, but let's hear Advocate Skippers.
Thank you, Chair. As I indicated earlier, I agree that it was provided late. However, I've indicated that I tried to get someone from the culture and from the language background of the two parties involved, and I could not find any expert in that specific culture and language. Therefore, Ms. Vetten was approached to assist us. Then she was not willing to provide me with anything without being given approval or just a promise that she will be remunerated for her services, because she's going to go through a lengthy procedure. She's going to watch the footage that's available on YouTube so that she can give an informed opinion on how the witness testified as well. As Advocate Butlander indicated, that it came out in cross-examination, the questions that was put to the complainant regarding sexual harassment and the power imbalances in the workplace. And that is why it was deemed necessary also to get an expert to come and testify on that. Since we adjourned last time, I did not stop trying to find an expert, but I could not get someone from the area and as well as from the background and the language. Therefore, Ms. Vetten was approached. The approval by the, I don't know, the Secretariat provided me, I don't know which one was, is it ours? The Office of the Chief Justice is the ones that needed to give the approval. So the approval from the OCJ only came through last week, Tuesday. And that is why the summary was provided the following day. And that is why it was succinct also. Because I put her on terms to say that the approval came through now, we need to give something. I agree, it was given late. But as Advocate Butlander indicated, we have dates in June, July. I know all of us, including myself, wants to finish this matter, but in the interest of justice and for us all to be able to understand the nuances in this matter, it is my respectful submission that Ms. Vetten should be allowed to testify.
Yes, that's a different aspect. Mr. Sikakane, on that, the first leg, preliminary one. I wondered to Advocate Butlander as to whether or not you people were on the same wavelength with regard to the kind of prejudice or the cause of prejudice. So I'm giving you the opportunity to respond.
Chair, two things. It's false that this is necessitated by me starting the debate about power. In fact, if you check the record, it is actually something I entered into because it was raised in evidence in chief. So it's a misrepresentation to suggest that I started the debate about power. It is actually something that was raised. Because the evidence leader entered the realm of theories of power with the witness, then I have to deal with it. So it was not started by me. And lastly, on the preliminary points, on the prejudice, Chair, I think it's something the tribunal must consider. But I don't know about whether you get a witness who's of a particular culture and language about the subject of power and relations. She knows better about what she means by that. Let's say she's right. How long is it going to take us? It's taken her 2 years to get a witness of this sort of, and it may take long. And so that's the prejudice is not necessarily curable, except that we would have to accept that the possibility of these proceedings taking as long as probably half of where we've been since we started is there. But having said this, Chair, I want to close by saying, be that as it may, and if you're not inclined to take the view we take, we are ready to start tomorrow. And if the panel wants to consider which decision to make, we are fine with that because it's a difficult issue maybe. But we would object because it's late, and the prejudice in my view is that already halfway through this case we are running, we are presented with the possibility of an expert with no report to read on a subject, as they say it's complex. So, Chair, we would prefer to use this time of this tribunal to call our witness while we're mulling over who would be prejudiced more. I do emphasize that the proceedings of this nature I know are difficult because everyone is walking on eggshells, but the process must be fair to both the complainant and the respondent. And we believe that this delay, this presentation of evidence really towards the end of an expert is unfair, even if my client is a man, is a respondent who must respond. I think it's unfair and nothing will cure it. But if time is not an issue, well, the only way that will cure it is that we must be prepared for a longer delay.
Yes, thank you. We may give our ruling now after some minutes or tomorrow morning. And because there's a possibility that we may give our ruling tomorrow morning, let us look into tomorrow. First thing I would suggest would be that should we adjourn here without having given a ruling, no party must assume that the ruling will go the one way or the other. So go ye forth and prepare your cases for tomorrow in case of A or in case of B. That said, I would like to ask Mr. Sikakane, you indicated more than once that you're willing to call the respondent tomorrow, which is Tuesday. And
Yes,
am I right to say it's Tuesday tomorrow? I thought Mr. Madonsela disagrees with me. All right. If we were to start tomorrow, maybe I'm going too much ahead. And you obviously anticipate that you'll finish with your evidence in chief.
Can I indicate I would finish in one day tomorrow if I were to start, but I need to take instructions about with my client's comfort levels with that if the tribunal, it would mean she must testify and then there's a witness, an expert coming much later. I would like to be given an opportunity to take instructions from my attorneys and my client about that possibility. But ready we are, and for time, Chair, I would take tomorrow from morning and I will be finished by at most 4.
Right. In the event your client has got some discomfort about testifying before the expert, would you then have some witnesses to call tomorrow other than your client?
Chair, I would like to take instructions on this
that
point.
one as well.
I wouldn't like to.
Okay.
I think I'll have to speak to my attorneys about who's available and what sequence would they have preferred. Thank you.
So we are not under any pressure. The tribunal is not under any pressure to give its ruling now, today. We will give a ruling tomorrow, but like I said, please proceed to prepare yourself for either outcome so that we don't have a wasted day or week. So we'll adjourn until tomorrow, 9:30.
Thank you, Chair.
Will that mean that Ms. Buntland then must also go and consider her position regarding witnesses?
Yes.
Yes, I'm happy to do that. I'll take instructions. That may
Yes.
add another dimension to
An aspect
to
which we also said we'd look at, all of
Yes.
us. All right, thanks. Yes, just a minute.
Chair, sorry, my attorney just as a practical issue is that maybe if we take instructions about the issues of whether there would be anyone to call, it would assist the panel. Sort of when you're mulling over this issue, you know exactly as opposition, is there any other witness that would start? I would actually take instructions about that and then with my learned friends tell the panel before we leave so that when you sort of make your own determination, at least you have a sort of full, the totality of the circumstances about witnesses.
And yes, related to that, it has just been whispered into my ear regarding the format in which further witnesses are planned to be had, whether in person or virtual, because the office of the GSC has got to make arrangements one way or the other. Whether it's virtual, arrangements have been made. Whether in person, arrangements have got to be made. So are we ready to, or is that tied up to who are the witnesses, or are we ready to indicate the format in which it is proposed evidence should be tendered? In other words, should we adjourn now? And then you're going to take instructions, we're going to talk to each other and also come and see us in chambers about that aspect.
Chair, I'm going to take instructions even on the sequence or necessity of certain witnesses. Thank you.
Yes. We will wait in chambers for that kind of report. For now, though, proceedings are adjourned until tomorrow. Thank you.
Thank you, Chair.